The fair use doctrine is not totally dead, but Congress nearsightedly crippled it in the short-sighted DMCA. If you are ever sued in court for copyright infringement, then you can still use the fair use doctrine as your defense. And you are not doing anything illegal if your copying of another person's work falls within fair use. Fair use is still the rule of the land in theory, but in practice it is on life support and fading fast, thanks to the DMCA. The DMCA is so far removed from the original intent of copyright law that I'm sure the Founding Fathers would be appalled by it. So now it is time to get into what the DMCA requires of YouTube. Actually, it requires very little. It does not, as I said, require YouTube to pull videos or suspend accounts. What it does do is provide powerful economic incentives for YouTube to act in the way it is acting. The DMCA says in effect to YouTube and other sites that if person A posts a video or an article that violates person B's copyright, then person B can sue both person A and YouTube for copyright infringement. However, if YouTube follows these steps outlined in the DMCA, then YouTube will be immune from a copyright lawsuit. The DMCA protects YouTube or any other ISP from a copyright lawsuit, provided they follow the procedures outlined in the DMCA. I am posting a link in the sidebar to an article I wrote explaining the DMCA process and how it can be used to censor others. But I'll explain the DMCA in this video as well because it's so important for you to understand it. I'm using YouTube in my example, but the process holds for other websites as well. Let's suppose I took excerpts from a video that you produced and posted them to YouTube without your permission. If you don't like my use of your videos, then you can send YouTube a DMCA notice, a complaint if you will. Your complaint is a legal document which you must sign your name to. In the complaint, you must sign a statement stating that you own the copyright to the work that I posted. You must identify the work that was infringed upon, and you must provide a URL of the infringing video that YouTube should remove. You must provide information that will allow YouTube to contact you, and you must sign a statement that the information that you have provided is accurate under penalty of perjury. When YouTube gets your complaint, they must remove the video that I posted in order to get the protection from lawsuits offered by the DMCA. YouTube must also notify me that the video that I posted was removed, and they must tell me where I can file a counter notice if I want to challenge your complaint. Now the ball is in my court. I can either do nothing, in which case the video stays removed, or I can file a DMCA counter notice in order to get the video restored. If I file a counter notice, then I must identify the video that was removed. I must make a statement under perjury that the video was removed as a result of a mistake or misidentification. That is what the law says, but if I posted a clip of yours that fell within fair use, its removal could reasonably be called a mistake. Then I must sign a statement saying in effect that you may sue me in federal court if you don't like the fact that I am filing a counter notice and making YouTube restore the video. I must sign this with my name, address, and phone number. YouTube must then send you a copy of my counter notice and inform you that it will restore the video in 10 business days unless you file a lawsuit against me. It will then have to restore the video within 10 to 14 business days, unless it receives a notice from you that you have filed a lawsuit against me. If you notify YouTube that you are suing me, then YouTube must refrain from restoring my video. And if you really do sue me, then the fair use doctrine might exonerate me, depending on how much of your video that I used and the circumstances under which it was posted. The DMCA also requires that YouTube must adopt and reasonably implement, and I'm quoting here, a policy that provides for termination in appropriate circumstances of subscribers who are repeat infringers. Note that the DMCA does not specifically spell out what a reasonable policy for termination would look like. It does not dictate how many times someone should be allowed to infringe before she is classified as a repeat infringer. Nor does it spell out what an appropriate circumstance for termination is. It only states that YouTube must adopt a reasonably implemented policy for termination. YouTube could, for example, adopt a policy that will only terminate people who have, in their opinion, violated fair use, and they still would be protected by the DMCA. At the very least, they could, and they should, adopt a policy of refusing to suspend an account unless there is clear evidence that at least some unauthorized copying has taken place. They could adopt a policy allowing a suspended user to write to them and state, "I never copied anything in the video that got me suspended." And then they should examine the video that was DMCA'd and compare it to the video which it allegedly copied from and determine whether any copying had in fact taken place at all. Or they should at least let a suspended person provide evidence that they had permission to copy another person's video. And once they received evidence that no unauthorized copying had taken place, they should restore the account. Indeed, the policy that YouTube has adopted, that you may never come back once you are suspended, is not forced upon them by the DMCA. Wendy Seltzer is the founder of the Chilling Effects Clearinghouse and a former lawyer for the Electronic Frontiers Foundation. I am posting a link in the sidebar to a blog entry by Wendy Seltzer, which suggests that the DMCA does not require permanent banishment. Now, the blog entry was made in 2003, and she wasn't talking about YouTube, but I doubt the DMCA requires permanent suspension or banishment. If someone from YouTube can point to case law that says the DMCA requires that suspensions be permanent, if someone from YouTube can point out where the DMCA says that someone who has committed copyright infringement must suffer a punishment that is longer in duration than the punishment given to a rapist or some murderers, then I will be happy to retract what I just said. In my next video, I will explain why I have not filed a DMCA counter notice, why the DMCA is unconstitutional, and how anyone can abuse the DMCA to get your account suspended. And short of going to court, there isn't a damn thing you can do about it. And even if you do go to court, there still might not be a damn thing you can do about it. This has been the Masked Analyst, under and in.